Well, we're here for another short lecture on litigation, and wanted to kind of bring you up to speed a little bit on important concepts in Chapter 5. And in this one, we're starting to talk about the complaint. So, important considerations in preparing the complaint. When we get to this chapter, remember we've already talked some about the investigation stage, taking statements from the client, trying to confirm those, perhaps with a police report or other information that you might be able to find on the subject. So, don't just come in and prepare a complaint cold, but in fact try to, develop the background a little bit so you're not going to get caught with a lot of foolish comments in a complaint. So basically, you need to think about the elements of the complaint. If it's a negligence complaint, for example, there's certain elements. If a contract complaint, it has different elements. And then the formatting of a complaint is very important because there's certain standards that judges expect. You don't just slap any old thing on paper like I've seen some students do. The law is very formal and it's very staid and follows a lot of certain historical precedents in the way that they do things, and so it's important that you format the complaint in the right manner. Well, it's important too to understand that you have to know what the local rules are, because some different counties might be right next to each other and do some things in a different way. Just for example, in the caption, I've seen captions in two counties right next to each other. One of them has the name of the court at the top left, others have the name of the court in the center, a third one may not care, may say you can do it either way. So you need to find out where you're going to work. There's going to be some specific rules. Some of you that have experience as a paralegal already can share information on the discussion boards with us on some of the ways that you are told to do things. Another thing in the area of the caption, since we're on that, others have always required that you use that right, the parentheses, you use the right close parentheses, all the way down about a third of the way down the page, in the middle of the page. Others use a star in that space or the asterisk. Still others don't have anything in that space. But they're kind of generally the same from the standpoint that you have justified on the left the names of the parties, then underneath the name plaintiff or defendant or petitioner or respondent or whatever your caption is supposed to use as far as how to address the parties. And then on the far right, right justified, you have the number for the case. Very top, as I said, you would want the court name, address, city, county, and state. Okay, also there are other considerations here on serving the complaint. What do we mean by serving the complaint? For example, on serving the complaint, to my knowledge, there's at least 3 ways to serve that complaint. One of them is what we call personal service, where you walk up to the person and you slap it on them. You've seen that in movies where someone gets served with their divorce papers, where a process server walks up and puts that on them. And that's common in big cities. In smaller towns, it's usually a deputy sheriff, somebody like that, brings the papers around and gives them to the person. Another kind of service that's very common is called copy service. Copy service is also called by some knob service. And what they mean by that is they'll take a rubber band and they'll loop it around the complaint and the summons, and then they'll hang it on the doorknob. Also, they have to mail a copy. So copy service requires 2 parts. It requires leaving a copy at the last known residence of the defendant, and also mailing by first-class mail, not certified mail. So copy service is first-class mail. The third system is actually certified mail, and so basically that's where you actually try to get the papers in the person's hand one way or another. I found that certified mail is the least successful of all these systems because the person is alerted, oh, you've got certified mail, and when you look on the card it says maybe Grant County Circuit Court. You're like, oh my gosh, I'm not signing for that. So they didn't ever sign, so you never get service on them. The fourth type of service is really the least effective of all, and that is the publication, service by publication. You're supposed to serve them in a newspaper of large general circulation in the county where the person lives. Well, you know, some counties don't even have a newspaper anymore, so that can be difficult. And then the only issue you have there is who reads a newspaper anymore? Very few people. So this whole issue of publication is important, but frequently problematic. If you can't get the person served, then the case doesn't really get going, and it can die right there on the vine because you never served the people. Another thing is amending or supplementing. Like I explained in one of the earlier sessions, facts can emerge in the course of the discovery that you can say, uh-oh, I left somebody out, or uh-oh, you know, I got this wrong. My client is just like anyone else. They're not always right. Sometimes they're confused. They're human. They were maybe unconscious part of that time, so they don't really know what exactly happened. So you may have to go back and amend that complaint. That's why it's better to know in the beginning what you're getting yourself into, because sometimes you may think, well, this is a great case, and then the more it develops, you realize, oh, this is a piece of junk, you know, or the opposite. I've had cases where I'm like, I don't know why I'm even doing this. Turn out great, make some money, everybody's happy, and you know, so it's kind of weird how that works sometimes. Going into it, you may have a first assessment of something, but it really takes a discovery process to really find out what you've got here. So the complaint itself, the purpose of it is to identify the plaintiff and the defendant by name, their county where they live, their city where they live, and then the court has to be shown that it has proper jurisdiction over the subject matter and the parties in the case. So here again, reminder that, and I've said this other places, very important, that generally speaking, you need to sue a defendant in his county of residence. A lot of these Indianapolis attorneys I've seen over the years, just a side note, they'll sue you in Indianapolis because why? Well, they don't want to drive to Huntington, or they don't want to drive to Logansport, or they don't want to drive to Spencer, Indiana. Well, sorry folks, but the rules clearly say that the case should be filed as far as personal jurisdiction in the county where the defendant lives. Now, there are some exceptions to that. There are 8 types of venue that are okay. And one of the things you need to understand is that generally speaking, a case can be filed anywhere in Indiana if it pertains at all to Indiana. But still, that's the venue side. The personal jurisdiction side says that you need to name the defendant in his county, not in some other county. So I'd be very careful on that. And especially what I've said in some things is in small claims court, this is very critical. And you see a lot of people getting sued down in Indianapolis for these doctor bills. They're being sued in Indianapolis by an Indianapolis attorney because they don't want to bother to drive to Tipton, Indiana or whatever over a $150 doctor bill. Well, it's not right, it's not legal. The small claims court rules specifically say that that person should be sued in the county where they live. So important considerations of just sorting out, well, you know, does the court have proper jurisdiction? Also need to set out a clear, plain statement of the facts of the case. Now, this doesn't have to be complicated. It doesn't have to be involved in a lot of mumbo jumbo. It should just really set forth what the facts are as you know them at the time, and, you know, make proper references to places, addresses, things like that. Someone's in a car accident, for example, on State Road 9, you want to put maybe mile marker 12, State Road 9, or State Road 9 and County Road 500 North. You know, something like that. It's got to be pretty clear so that the person on the other side, when they read it, can understand. But like I say, it doesn't require a lot of legal jargon. Important thing too is that you need to include all of the elements for negligence, for example. I've seen people prepare complaints that the gist of it I can kind of gather is about negligence, but never once in there do they use the word negligent. They never say the defendant was negligent. And then there's about 4 other elements involved in negligence, so, and we'll hit on those more later on, but you know, there's nothing in there about duty or anything else that pertains to a negligence case. So it's important to be plain, be specific, but also be factual. You've got to include all the necessary facts. Now, another thing to consider is, you know, at the end there has to be some kind of a demand. Now, this is important in Indiana because the demand statement should not say, you know, $1 million. Okay? The state of Indiana did away with this in the rules a long time ago. And it's basically, they want, you know, here again, a general statement on damages. Like, damages sufficient. To repay the plaintiff. Kind of words to that effect. So if you're in a negligence case especially, don't go in there and say, we want $1 million. Instead, say something more general. That's what the courts want you to do. Because they don't want a big splash in the newspaper. Well, so-and-so sued so-and-so for $10 million. You know, so, you know, that's not the way that works nowadays. Important thing here is to make sure that demand is stated in a proper manner. Now, another thing that's in the notes here is the issue about federal kind of jurisdiction. Should you bring your case in federal court? For example, if it's like a civil rights case, chances are you may want to bring the case in federal court. On the other hand, though, there's no rule that says you cannot bring. In fact, the rule is just the opposite. You can bring a civil rights lawsuit in a state court. So just because certain words are involved doesn't mean that you have to bring it in federal court. One of the things to keep in mind, federal court, very big, very busy. It covers a big region, of like a third of the state, so you don't want to waste their time with some smaller type things. You'd never bring a really small kind of a lawsuit that you know is over a small amount of money. You've got to bring it over larger, more complex litigation. One of the things too is the diversity side of it. Here again, diversity requires that the amount in question has to meet a certain amount. It changes all the time. I think when I started it was $10,000, then it went to $50,000, $75,000, and so forth. So very important. That's how one way they try to control how often that court is used for complaints, because they don't want it to be cluttered up with a lot of small claim lawsuits that ought to be in county court. Okay, basically we've said, you know, a complaint, it identifies plaintiff, defendant, court has proper jurisdiction, factual basis for the suit, request or demand for relief. You know, is there any other jurisdiction that you need to consider? You know, somebody out there, one of you that does a lot of these, it would be good if you go on the discussion board and either attach or write in the body of your work area, write up a sample caption of what you use. And looking at the one that I'm seeing here in the notes, it has a straight line after the parties' names. Like I said, I've seen where they use that right close parentheses, and I've also seen where they've used stars in that area. I think there's a lot of variability on that one thing. Also note though in here that it's centered on the top for the name of the court. So you know, here again I'm trying to get across to you, I've seen that done at least 3 or 4 different ways. So it can be left justified, right justified, centered, and so very important to find out what the local rules are. Important to name the real party in interest. This is big. We need to look at what that is. What is a real party in interest? Real party in interest has to be a person that has an interest in the lawsuit. You know, I've had cases, I've read them, I've involved myself in them, where you might initially think, well, yeah, this is the real party in interest. Where you get into trouble on this, you get into like in the area of what we call the family purpose doctrine. Family purpose doctrine, let's say teenage kid takes dad's car at the age of 15 and he's driving it without the father's knowledge. And you know, is the father the real party in interest? Can the father be the real party in interest? This is the kind of legal research that you've got to do to make sure. Well, who has the insurance on the car? Certainly not the kid. He's not even old enough to drive. Or if, let's say that someone in the family is driving a car, maybe it's a 20-year-old daughter or something in an accident, and you want to name the parents. Well, she's over 18. Why would you name her parents? You know, well, because the father has an umbrella policy that's worth $1 million, and the little girl's policy is only worth $25,000. You know, so you've got to be careful about that, though. Guys have gotten themselves in trouble trying to overreach too far, because there is no family purpose doctrine in Indiana. So if you're told by the court, well, you shouldn't have named this father in this lawsuit, then you've got to get him out of that lawsuit right away. He's not a real party in interest. If you leave him in that lawsuit, that is what you call a frivolous complaint, and the firm will get burned on that. So, but that's between you and the lawyer that you're working for. But very important that you understand, so you can assist him, that we've got to be, this is a touchy area right here, that we have to name the real party in interest. So it sounds kind of simple, you would think, in terms of these issues. You know, well, you know who was driving and all this, you know. But let's say, for instance, someone is driving a semi-truck for a big corporation. The driver, maybe he just recently filed bankruptcy. Well, I mean, is the company responsible? Well, under what we call the master-servant doctrine, yes, the company would be. So the company would be a real party in interest. We also call this, just for you Latin buffs out there, respondeat superior, or some say respondeat superior. And so here again, it's interesting, you know, it seems kind of simple, plaintiff, defendant, but there can be little variances in here, and you've got to be somewhat careful in that area. So some things to think about. in preparing that complaint. One thing too that I think is good is, I touched on this a little bit, but I think it's important that we look at the issue of venue. Like I said, you need to look at the rules of civil procedure, specifically on venue. It's one of the really low rules in the numbering. You might say, well, best venue is the county. The defendant lives in the county. They can also have where the accident happened. Maybe they're both traveling somewhere out of county. So the place where the thing happened. So basically, also a corporation, they have an office in that corporation. Let's say it's a shoe store, and they've got a store in that county. So basically, could also be a house, real property located in that county. So there's some kind of lawsuit involving some kind of real estate in that county. So there's different ways to decide these type things. Another thing they bring up, I touched on this a little bit, but minors. Minors, that is to say children, not coal miners, but little kids. You want to sue a child because like they threw a ball, it went through the window, it broke the glass hit you and put out your eye, okay? Stuff like that's crazy, but it happens, okay? Well, actually parents are liable in the state of Indiana, but here again, research. You've got to dig into that, find out, what's their level of liability, negligent acts of their kids. Another thing to keep in mind here again, household insurance a lot of times will cover those types of liability. So when you have like the fire insurance on your house to pay off the mortgage, it also has a liability section to it where someone slips on your sidewalk, they'll pay for it. Someone gets hurt because your children are playing and they hit them with a ball, they'll pay for it. Someone falls in a hole in your yard, they'll pay for it. So important considerations in that. So basically, a lot of times where there's a child, you might want to name the parent as the guardian ad litem. Now here again, that can work under that real party and interest thing, because a child under 18 is really too young to be a party to a lawsuit. So you really need to word it just right. So it's important here again in preparing that complaint that the wording is correct. The book goes into issues like class action lawsuits, very complicated. Class action really has to be, the class has to be so big that you cannot really number it easily. So if you've got 20 plaintiffs, for example, and you can name them all, that's not really a class action. But if you could have thousands of plaintiffs and you can't even name them all, it takes time to sort out. You've even got to do discovery from the defendant to find out who the members of the party are. First thing you do is you file the suit, then you have to certify the class, that it is big enough, and then you've got to find out who these people are, and you have to notify them, and then they can join in the suit or not join. Remedies we've talked about before. Remedies most of the time are in the area of damages. Very important that we cover that. They can be compensatory damages. This can be lost wages, doctor bills, pain and suffering, or they can also be what we call punitive or exemplary damages. A lot of you have heard about the McDonald's coffee case, and there were some punitive damages associated with that. What most people don't know is that the judge stripped out most of those damages, and the case ended up being resolved for a lot less money than is often said, like $10 million, $6 million. Well, it was actually more like $500,000, So basically, still a lot of money, but not in the millions, because the judge stepped in and lower the jury verdict. Equitable relief is also available, and that would be specific performance. Somebody started to put a furnace in your house, they walked off, they didn't finish it. Rescission of a contract, restitution. Someone does that and you don't trust them to finish the furnace, then you want your money back. Another could be what we call quiet title, or the last one, a lot of times commonly, is injunctive relief. A lot of times you'll see in a divorce, for example, a temporary restraining order. And you know, early on in my career, temporary restraining order was very common, and now it has become less so. And they used to give those out ex parte meaning that there was no hearing and the person had no notice. Well, that is not favored, okay? Because over time, people have taken advantage of other people, and because of the due process aspect of this, you know, these ex parte orders are not favored. So you're seeing the number of temporary restraining orders shrinking, but you do still see them. And then there's another thing called civil protective order, which is also seen. Those are almost interchangeable, where the guy can't go around the woman's house and this type thing. They are complicated. We'll get into it a little bit more later. But when it gets into the area of visitation and things like that, how does that work when there's a restraining order? But you know, that does happen. It can happen. It can be part of the request in the complaint in the area of the remedies that you're asking for. One of the things they bring up, and here again I've told you this, every county has different rules. I mean, does the complaint need to be totally flat? Does it need to be attached to something? Some of them still require like a blue backing you know, this type thing. Don't fold a complaint if you're going to mail it in to some courts like Huntington Superior Court. It has to be flat. So, you know, when you go to mail it, for example, you need to mail in a large envelope, not in a small envelope. These are little silly, dumb rules, but it's just the way it helps them be more efficient in their work, because they don't have to unfold this, get the creases out, so forth. Summons. Important in a summons, you've got to give the person's name and address, the plaintiff's attorney's address, request for an answer, time limits. Very important. Is it 30 days? Is it 23 days? What is it? You know, statement of consequences. In other words, you will be defaulted if you fail to answer. You know, basically, you know, these are the type of things that need to be included in that summons. Here again, the service of a summons goes with the complaint, and I mentioned it. And basically, you know, you can knob the service, which is called copy service, or you can personally serve the person. Sometimes the people will be in the house, the deputy's knocking on the door, they peek out the window, oh, I don't want those papers, but that doesn't mean they get around it. The guy can leave the papers in the door and then mail a copy later that day. So when you go to produce those summons and complaint, you need to produce a large quantity so that they can not only drop off a copy but mail a copy if necessary. So those are important things to consider. One of the things too, last thing that we're going to touch on is amending the complaint. Amending the complaint, Rule 15, look that over. You know, here again, evidence comes about in the process of discovery that you realize that, hey, I got this part wrong, we need to change it. The facts are kind of undisputed here. There was a misunderstanding. I don't know. Something emerges and we need to make changes in that. So look this over, read through your material, be sure to respond to discussions. Let me know if I can help you in any way. Go in through communication, send me an email, or if it's vitally important, you can also call me. My number, my address, and everything is in the syllabus. So stay in touch. I'll do the same. Look for more of these lectures. Thanks a lot.